Okay, abusia bɛ mu akɔ aba sonko so ɛde ba POG Media so. Yɛde mbɛkɔ political highway ni so highway ni deɛ nsɛm bebree wɔ so a yɛn nso yɛagye pɛne sɛ bɛmi abadwafoɔ no ahu deɛ ɛrekɔ ɛne deɛ ɛreba. Abusua moma yɛn mbɔ nwura yɛn nsɛm no mu. Ɛyɛ Supreme Court ɛne ɛyɛ EC regulation a kyerɛ sɛ Supreme Court a cancel NPP Cite&Collapse illegally were declare among na we na NDC for ababonten a omo kyerɛ omo no omo nim sɛ saa de we no ebe happen cause omo full evidence a ɛyɛ sɛ omo dey protect omo seat and beside ɛno no cramp no ɛyɛ electoral commission no is no wadi kan declare NDC dada into no enya court crampo ɛna ɛbɛma saa order ya NDC for no mo ya we say saa nneɛma we no it will come to at pass into ɛno no ama ɛkyɛ sɛ J-Mensa na ɔno no odi ɛkyɛ sɛ all because of her party affiliation no ɛno no ama yɛ Supreme Court no ɛkyɛ sɛ ɔmo a ende ne career crampa ɛkyɛ sɛ J-Mensa no wanu no ho nneɛma na ɔyɛ no wanu no ho ma yisi ano NDC in parliament no ɔmo ani abere ama ɛkyɛ sɛ Supreme Court ɛkyɛ sɛ Supreme Court ɛta ɔmo akyi a ɛkyɛ sɛ ɔmo de massive support ama NDC amanyɔkuo ne sɛ ɔmo police a ɔmo evidence na ɛkyɛ sɛ ɔmo nso ntae ɔmo akyi na ɔmo declare ɔmo seat no mo ma na sɛ ɔmo seat no ɔmo retrieve ɔmo adeɛ ɛyɛ NDC ɛyɛ computer waba abɔnten ɛde nsɛm bi aba abɛto dwa ɛkyɛ sɛ nsɛm no ɛnyɛ easy kora yɛn nsɛm mbɛ mo yɛnkɔ na yɛnkɔ nkɔti nsɛm ɛkɔ so na asa na ɛbɛkɔ no wowɔ nsɛm kan bi afa hyɛ yɛ comment section like na hyɛ ma afoforɔ nso ɛnsa ntumi ɛnka bi bɛdam ase.
For the Electoral Commission to collate the parliamentary results of 4 constituencies in the December 2024 elections. Now, what happened earlier today is that the affected constituencies, as we do know, Okaikwe Central, Tema Central, Techiman South, and Ablekuma North. This is one that has generated a lot of conversation ahead of that Tuesday date that this High Court is expected to sit to decide on the matter going forward. But earlier today, the Supreme Court quashed an order by the Accra High Court for the Electoral Commission to collate the parliamentary results of 4 constituencies in the December 2024 elections. Now we're talking about Akaikwe Central, Tema Central, Techiman South, and Ablekuma North. We saw what happened last week, Saturday, that's at the Electoral Commission's offices, the Greater Region Office of the Electoral Commission, where this collation was done and redeclarations made in the case of Tema Central and Okaikwe Central, and also Techiman South. For Ablekuma North, that issue was not resolved last week because the returning officer there indicated that he cannot continue the process without the presence of the NDC. Now, what's happening is that the Electoral Commission now, based on the electoral laws of Ghana and the reference and the judgment by the Supreme Court today, the status quo has been restored as per the time when the declarations were made during the election period. This is what happened at the Supreme Court earlier today. Take a look.
It was plain to the trial judge that the clients of Mr. Godwin Edoji Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West African Examination Council, for failure to accord persons a right to a hearing. The statute under which the West African Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West African Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edwidge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling.
This is Gabriel Paman, who is the president of the 5-member justice who sat on this particular case and delivered this ruling earlier today, effectively quashing the recollated and redeclared results in these 4 constituencies that we're talking about: Tema Central, Okaikwe Central, Ablekuma North, and then also Techiman South. Now, the other 4 justices who sat on this particular case, together with Justice Gabriel Paman, we're talking about Justice Jehu, Professor Henrietta Mensah Bonsu, and Justice J. Frimpong, and then Justice Anthony Kofi. They made up the 5 justices who sat on this matter. It was a unanimous decision, as a matter of fact. You can say 5-0 for that matter. But look at this. So what it means is that even though after Saturday, the Electoral Commission, after they did their recollation, declared Patrick Yabuama as MP-elect for Okaikwe Central, what this ruling effectively means is some lawyers have expressed the view, reverting to the status quo of what happened or what was the case before the High Court decision. But we see as well in Tema Central. On Saturday, Charles Forson was declared MP-elect. But then again, before that, the Electoral Commission had declared Ebi Bright as MP-elect for Tema Central. For Obuasi East, and that's what we're going to be finding out from the NDC, why they did not add or argue the Obuasi East case today. Are they going to take up the Obuasi East case at another fora? Because the Obuasi East situation actually follows in the same stead of what we saw in Tema Central and then also Okaikwe Central, where there was a declaration of Samuel Abuaji, that's the NDC parliamentary candidate, for the Obuasi East constituency as MP-elect on the 9th of December. But then again, afterwards, days after, the Electoral Commission did the recollection that was on Saturday and declared Patrick Waje Iadom as MP-elect on the ticket of the MPP for the Obuasi East constituency. We didn't see that being now reversed today. We'll find out from the NDC why this is the case, or why it was just the 4 constituencies that this particular ruling today by the Supreme Court is limited to. But some lawyers have made a case that there may be a legal challenge in the coming days, and that the NDC, for instance, now cannot take this to be a victory in totality because of the circumstances at play. Now, what happened in court today was a court simply saying that for the fact that they were not giving a hearing during the mandamus application at the High Court by the MPP, they should go back so that they will be heard. Now, that has 2 possible outcomes. Either it will be granted or it will not be granted. And here's what the lawyers make the case, that there's also that other situation where the MPP may just decide to go back to court and withdraw that application so that that Tuesday hearing, that's the 31st December hearing, may not even happen at all. Now, even if with the possible outcome from that High Court hearing, whether it is granted or not, there's even a bigger challenge where the Electoral Commission has already declared the results for these 4 constituencies. They have gazetted the results for these 4 constituencies that the courts have ruled today that the Electoral Commission declaration doesn't hold. In fact, there's a rate of elections that has been submitted to the Clerk of Parliament indicating who has won these seats in whichever constituency, the 4 we are talking about. In fact, registration has already started, and some of the MPs, as we're learning or were communicated to by the memo from Parliament, should have already started the process of registration online. So how is the NDC going to deal with all of this? And what does this really mean in law is that the EC has performed all the functions it has to perform in respect of that election. And that's why they say the EC has become functus officio. Now, let's bring in Dr. Cite&Co computer right now, and we're working on the telephone lines to get through to Haruna Mohammed, who's Deputy General Secretary of the MPP. But Dr. Cite&Co, appreciate your time. Certainly, we can heave a sign of relief with what's happened today, is it not? At least based on the Supreme Court's ruling today on these 4 constituencies.
Yeah, Alfred, let me say good evening to you and your cherished viewers and the good people of Bimbilla and Williamson constituencies. Alfred, clearly, you remember I've been telling you all along with all the interviews you had with me that what the EC was involved in was a complete illegality. And I knew that this will come to pass because what happened at the High Court on the 20th of December was complete travesty of justice. I mean, it defied logic. The ruling by the High Court, the trial judge who sat on the matter completely. And you saw what happened. You saw how the Supreme Court tactically and magnanimously reprimanded him for what he did. It just didn't make sense. And if we had allowed it to glide, dangerous precedent was going to set in this country. And our democracy would have been in shambles. It would have been in shambles, and our electoral system would have been in tatters. And so we as a political party, NDC, we are grateful to the Supreme Court for arresting this kind of illegality that the Electoral Commission that has constituted itself into some lawless institution of late, just misbehaving and trying to get away with it. They did that in 2020 and got away. So they thought this time around, the NDC is going to fall its arms and allow them to get away with that kind of illegality that they have been doing. After what is the matter? It's a simple issue. The issue is about collation of resource. And we all know that the CI want to serve, like I've been saying all along. Regulation 43 is very clear about how collation is done. Now, if the returning officer who is clothed with the power of declaring resource at the Constituency Collation Center for parliamentary election, when he satisfies himself that I've done the processes, I've gone through all the processes of collating the resource and declare the resource, he cannot come back and do another collation again and do another declaration. It's not done. We don't have it. In fact, we don't have any scintilla of evidence of that nature. Even the examples they used to give of 2004, this was not the incident. We are talking of declarations. Now, if you look at all their examples they gave, none of them involved declarations. They were just like process of collation. Something happened, they couldn't finish the collation. They regroup in another place to do the collation and complete. Or they were counting and something happened, they couldn't finish the counting. They managed to salvage the boxes, run to the regional capital and do recounting or recollation and now declare. And our case now is about declarations. Alfred, that is our case. And then so when the trial judge refused to listen to us and admit us into that matter, we knew that there was a collision somewhere.
Well, but you raised the question of bias today. Your lead counsel, Godwin Edugyi said that the court did not agree essentially with him on that particular question of bias.
Alfred, I said they magnanimously agreed to it by asking that the gentleman should step aside. By asking him to step aside from the matter. It was a complete reprimand. First, they quash his decisions. Second, they asked him to step aside from the matter. He shouldn't hear the case again. What does that mean? It's a tacit way of reprimanding him for what he did. Clearly, he just pushed the law into the gutter and started to do his own thing. And did his own thing at the end of it. And thought that the NDC was going to be cowed into that kind of ruling. We will not accept this. And I've been saying that's why we refuse. We rejected it completely.
Well, but
today, the laws have risen with us. And they've seen that, yes, natural justice demand that they should have allowed us to join the matter. Because those decisions he did, subsequently, what did they do? The Electoral Commission, the following day, quickly started declaring 7 seats for MPP in a row. That kind of charade they did over there.
Well, it is that particular reference you just made about what happened on Saturday, because the Electoral Commission acted on the orders of the High Court, which decision has been quashed today. Now, what's happening is that, and some have argued that you may be faced with, even though you have a reprieve today, you may be faced with a bigger challenge. The Electoral Commission, we understand, has already submitted a writ to the clerk to Parliament. We understand that these results have been gazetted, and then also the MPs have started registration already. So how is this ruling going to remedy the process that is already in motion?
All the processes has now been arrested by the ruling by the Supreme Court today. It means invariably it doesn't exist. That's what it means. All the gazette notification, the letters sent to the clerk of Parliament, all are moot. There are issues that doesn't exist. By the ruling of the Supreme Court, it means they have to start all over again. They have to completely come and start all over. So if they even send the gazette notification to the Ghana Publishing Company, they have to withdraw it completely. It means it doesn't exist. Whatever they did over there, you remember I told you it was a Bawumia package they were giving to themselves, and that it was not going to cross to New Year, and it came to pass. You know my prediction. I predicted that package they were just giving themselves. It won't go anywhere, and actually it came to pass. Nothing is going to happen after it. We are going back to the court. Now I heard you talk about the issue of Obuasi.
We're gonna come there for the Obuasi. Is this an automatic, as it were, consequence of the ruling today, that even though the results have been gazetted, and in fact the rate of elections sent to the clerk of Parliament indicating who has won these constituencies, effectively this ruling would reverse this process? Is that what the consequence of this ruling is?
Yes. It means all action taken after the High Court orders are being quashed. They are being set aside. And you know, all these things, they took it after the High Court. They went Saturday and did their oath. In Monday, they quickly went and gazetted the action they took on the Saturday and all that. So all that has been set aside. So it doesn't exist completely. So they now have to come and do re-gazette. Maybe they might decide to take away the 4 constituencies and gazette another group. You know, they gazetted 274, right? So now if they take off the 4, that means they can only gazette 270. And so that we battle them out with the other 4 in the High Court, that the mandamus thing they are talking about. We'll go and battle them over there with it.
I see. And for the Obuasi East, and that's one reference I made earlier, the fact that the circumstances in Obuasi East fits in what happened in Okakwe Central, Tema Central, and then also Techiman South. But then again, we didn't see Obuasi East as a subject of this ruling today. Why is that?
Yes, you see, what happened is that when they brought their writ of mandamus to the High Court, they removed Obuasi East. Obuasi East was not part of their writ. It wasn't part of it. They removed it. And as well as this place, I have found no Southwest. That one too, they didn't add it. And Domi Kwabenya. You see, they didn't add those ones. They cleverly removed those ones and just hinge on 6 areas. That was what they filed over there. Now, when they got this ruling, interestingly enough, Electoral Commission surreptitiously and secretly through backdoor added Obuasi is into their declarations, and that of Hafano Southwest. The two of them were smuggled onto the Saturday declaration they did at their offices there. So, but the mandamus, the case that we are fighting in court, didn't include these two.
So the court order a week ago did not include Obuasi East and Ahafano Southwest.
It didn't include Obuasi and Ahafano Southwest, and that of Domi Kwabenya. It didn't include that.
But then we saw redeclarations made on Saturday by the Electoral Commission.
Good. That's why we are saying that we are coming in another form to deal with that matter. It means they smuggle it in, and you know, we didn't participate. But it was when they started doing the declaration, announcing it on TV and radios, that we got to know that they've added Obuasi East and that of Ahafano Southwest. And we're preparing to work on Domi Kwabenya. Meanwhile, it wasn't part of the one they sent to the High Court. The ruling of the High Court, none of these 3 constituencies were part of it. And so they were just doing some illegality behind the scene, using the ruling they got from the High Court to expand their frontiers into all illegal areas. That's what they were doing. But interestingly enough, we got the ruling, and we are going to pursue those 3 ones. We are not going to allow it to rest. You know, Domi Kwabenya is not part of these issues. So they've invited us tomorrow to come, IPAC, for that one alone, for the 3 polling stations, to deal with that one tomorrow. And your guess is as good as mine. Like I told you the other time, it's not an issue. It won't even get to 10 minutes in trying to resolve that one, because we have a good case. We have the pink sheets, and we'll present it to them tomorrow, so that the Domi Kwabenya will be out of the.
Because I recall that
Madam Christina will declare.
I see. Yesterday we had indication that there was supposed to be an IPAC meeting today to take a decision on this Dom Kwabenya and then Ablekuma North. And it appears the IPAC meeting didn't happen today, as was scheduled.
Yes, because of the Supreme Court ruling today. I mean, all of us were in the Supreme Court. Bosman and Tete and Co, they were there at the Supreme Court. Okay, so there was no way we could have it. In fact, they gave us a message that tomorrow we'll have the IPAC meeting to deal with Domi Kwabenya and Ablekuma North. But after the ruling, they took out the Ablekuma North because the court quashed that thing they were trying to do. So as we speak now, the only issue on their table is the Domi Kwabenya, which they can deal with because no court issues is affecting Domi Kwabenya. And so we can deal with that one tomorrow as they invite us. But those other ones, they smuggle inside. And you heard what the trial judge said when the laws were given their orders. And so we'll deal with that one on a different level. We'll deal with that one.
Okay, so you're going to deal with Ahafano Southwest, where the Eric Nana Ajuman Prempeh was declared as MP-elect as against Eduse Kwesi, that's your candidate. And then also what we saw in Obuasi East. So those 2, you're going to deal with them at a different forum, from what we understand.
Yes, that's it.
And when is that process going to start? When is that process going to start? Because already you're racing against time. The 9th Parliament is going to be sworn in on the dawn of January 6th into January 7th. We have just a few days away. So if you're going to deal with it on a different forum, when is that process going to start?
Very soon. In fact, our lawyers, as we speak, they are in business. They are in conclave, trying to put the documentations together. You know, the court gave us 2 days to do the filing. Okay, so as we speak, they are in conclave. I've just forwarded some documents and information to them about the cases. and they are working on that. They are seriously working on it. I can assure you, within the 2 days, we are going to, you see a semblance of it. And the issues that they asked us to go back to court on 31st, you will see the argument we are going to put out there. That mandamus, you see, mandamus is a writ that is calling on the state institution to perform their action that they are not performing. You see, that is what they are trying to do, and we will let the court get to understand that those actions were performed, not that they didn't perform. They performed those actions.
I see.
Those actions were performed by their assignees, who are the returning officers. That is what the law says. The CI want to say they assign those roles to the returning officers, and they perform those actions on their behalf. So if somebody goes to court in a writ of mandamus, now forcing that the EC has refused to perform certain action, who told you they didn't perform those actions? So there's a documented evidence to show that they performed those actions. It's just that you are not satisfied with the action.
Well, yes.
So
the Electoral Commission has held consistently. Section 43 is what you're making reference to, CI 127.
The Electoral Commission, that is it. They follow through the process.
Yes. But the Electoral Commission has consistently indicated that, yes, their officers fulfilled requirements under Section 43, but under circumstances that invalidates the process, and in fact, the outcome of it being duress, and then also in some cases, pink sheets not being complete, and then declarations made. They have consistently held that as a result of those instances, it invalidates the outcome. In fact, it did not follow due process. That's been their verdict, is it not?
Alfred, it doesn't lie in their mouth. They don't have those powers. They don't have those powers. That is the problem we have with them. And that's why I always describe them as lawless institutions. Oh. They don't have those powers. In fact, if you go and take PNDC law 284, subsection 16 and 20, it talks about the issue they are just raising. If you allege that somebody did a declaration through intimidation or duress, or they didn't complete the collation process and declarations were made, the environment to go is the High Court. Under our Constitution, that is Article 99(1), the High Court had jurisdiction over that matter. So that is the time we will now cross-examine those people. They'll put them in dock. For us to cross-examine them, to solicit whether they were actually forced to do the announcement or not. These are the issues. They know it. It is not the Madam Jean Mensah and Tete or Bossman who should go and be doing those things. They don't have that power. When you force them and ask them, okay, show me under the CI 127 where you have the power to say that the processes did not follow due process, or they were made, and so we have the power to recollect. My brother, I wish you get him online. Said it this afternoon. There is no recollation in our electoral system. There is nothing like that.
Okay.
It is only High Court that can call for a recollation by setting aside a collation system done at the collation center, or setting aside a declaration.
Right. And just for the benefit, right, just for the benefit of our viewers, and we're going to pull up the specific PNDC law that you make reference to, and this is going to be on the screen right now. And this is the PNDC law 284. That's what you reference, correct?
Yes, 284, subsection 20.
Subsection 20 is what you have there. Grounds for challenging election results. The election of a candidate shall be declared void on an election petition if the High Court is satisfied, A, that general bribery, general treating, general intimidation, or other misconduct or circumstances, whether similar to those specified in this law or not, have so extensively prevailed that they may be reasonably supposed to have affected the result of the election. So the grounds for cancelling election results is quite clear here. Bribery, general treating, general intimidation. And that brings in what the Electoral Commission has been talking about, Dr. Cite&Collapse.
That is what I'm saying.
A number of their officers, they say, made these declarations under duress, intimidation, or any other circumstance that not specified in the law. So you're saying, if that's the case, it's the High Court to determine that, and not the Electoral Commission, because the law is quite clear.
Alfred, that is what I've been saying. You see, I'm vindicated. The law is there. And they know this. That's why I'm saying that they shouldn't constitute themselves into judges. That is not their it doesn't fall within their mandate. If I'm aggrieved, I'll come by petition. to a high court and invoke this subsection you have just read to the general public, so that the high court will look at it, they will assess it, the evidence before them. But you don't come on mandamus and you are forcing the electoral commission that you think that the process were not duly followed and that they must go and do recollation for you because they have refused to collect. And who told you they did it? They have declared the results. The evidence are there. Now anyway, you only have this window. They should go there. Okay. And they shouldn't be constitute themselves into some lawless institution and getting away with it. We are not going to allow it.
Let's hear from Gary Nemakon, who is private legal practitioner, lead counsel for the NPP candidates who also were before the Supreme Court earlier today. Take a look.
NDC said they were not heard on the application. They came to court to say that they were not heard. The court said it's a fundamental rule to be heard. So go back to the court and have your matter heard. So it's simplicity. We are going back on Tuesday. They will file their response, okay, on why they think that there was collation or there was no collation. The court will hear the matter, make an order for EC to go and make collation and a declaration. That is the point. So it's not about recollation. So this word recollation, there is no collation at all.
Well, so that's Gary Nemakon there, essentially making the point that there was no collation, even to talk about declaration. Dr. Cite&Co.
Well, that is what I'm talking about. We have evidence, and that's what wanted to join the matter and ask the trial judge to watch it and see whether there were declarations or there were not declarations. These are returning officers who held the Form 1D, which is a summary sheet, and announced results from it, and held the hands of our candidate that they were validly elected as parliamentary candidates. That's their rules. This was done. Now somebody is not satisfied with the declaration and ran to electoral commission office, the commissioners, asking that they should come and do a recollation. And they also constituted themselves into judges and determined that they were done under duress, and therefore they didn't follow procedure. So come back, let's do another collation. To the extent that they even appointed officers in the morning to do recollation and announce them as winners. That was a complete charade. If it's not charade, I don't know how you describe it again.
Right. So you're saying
that is the issue we are talking.
Okay, great. So you're saying that in the cases of Fantiakwa North and then also the case of Obuasi East and then Akuffo North Southwest, these three constituencies, you are going to challenge the outcomes as was declared by the Electoral Commission at a different forum. We'll wait for how the coming days will look like on this. Yeah, so Tuesday, Alfred,
yes. Not
Tuesday,
that one
in a minute. Yes.
In Sawam Adwajiri.
But in Sawam Adwajiri, why is that? Because today you had a second application. You had a second application before the Supreme Court. And you withdrew that application.
We are going to challenge it.
But you withdrew that application today.
We'll come with another application.
So why did you withdraw this one? Why did you withdraw the second one?
Our political highway, so a NDC computer and I telling about a Supreme Court ruling. Just say, more at the EC at the level, no, and no one seminar it will go in. But I must say, Moje Penny Cocotti, Sir Odui, Edmai, aha, POG Media, so, but I must say.